What I'd like to do this morning very briefly, as I've highlighted at the CPA conference, is take you through the Constitution of Fiji, which obviously is very, very important. It sets out the fundamental legal framework for governance. Whilst bureaucracy, red tape may be various challenges, but what is also a significant issue in Fiji is political stability. And if you read the recent IMF report, which has actually been very, very positive, and has highlighted also that it does project a growth rate of about 3.2% based on the many structural reforms that have taken place. The reality is that we need to have a specific regulatory framework in place for the governance of the country. And we've got up on the board, and I've also, I understand you've also received copies of it, the Constitution, which will be assented to by His Excellency the President on the 6th of September, which is this coming Friday. Some of you, I understand, may be receiving invitations for that also today. But very, very quickly, I think there are about 3 or 4 key areas that I wish to highlight to you, which has always been at the forefront of political debate in Fiji, and indeed at the forefront of what one may call instability. It does affect things like price control. It does affect things like bureaucracy, access to bureaucracy, and indeed how you are treated by the bureaucracy. Because if you have a constitutional framework which sets out a political framework that depends on communalism, clientelism, and which leads to corruption, then obviously we'll never progress. What this constitution does is try to address those key fundamental issues. So we can put it to rest. The matter can be put to rest. And we can then focus on improving processes, improving systems, improving economic growth rate, decreasing unemployment. And that's what really should be the focus of all countries. And indeed, most countries do focus on that. So, very quickly, I think some of the key features, I'd like to take you to the preamble, if you have copies of it. We had put out a draft, and I'll go through this very, very quickly. In the yellow is what is highlighted in terms of the recognition of the indigenous people of Fiji. Without going into too much detail, it basically puts to rest the idea that we do recognize group rights. We recognize the indigenous people or the Itauke people of Fiji, the ownership of their lands, their unique culture, custom, tradition, and language. Similarly, we recognize the indigenous people of Rotuma, their ownership of their lands, their unique culture, customs, tradition, and language. And then we recognize the descendants of the indentured laborers who were brought from British India, which is what it was then, and of course the Pacific Islanders. In Fiji, they're commonly known as Solomon Islanders. Their culture, customs, tradition, and language. And of course the descendants of the immigrants of others and the settlers to Fiji, and their customs, tradition, culture, and language. You see the distinction there is between the first two groups is firstly their culture is unique because it is indigenous to Fiji. Nowhere else in the world is it practiced. Nor is anywhere else in the world are those languages spoken. And number 2 is of course the recognition of the ownership of the land, which is held in a communal ownership form. After recognizing all the different groups, we all say that we are all Fijians, united by common and equal citizenry. That is essentially the fundamental foundation of any great country. If you look at any modern nation state, the notion of common and equal citizenry always prevails, and it must prevail. The example that I always give, very simply, when we were in Kandavu some months back, I say that because I see Colonel Kurusingha here, is that we call David Campisi an Australian. David Campisi's parents migrated from Italy in the 1950s, but we don't have any problem calling him an Australian. In the same way, Barack Obama's father was a Kenyan, but we don't have any problem with him calling him an American, and he is now the President of America. The next most important point, I think, is people have talked about the Ku culture, is Section 2 of Chapter 1 of the Constitution. There is a specific provision, subsection 5, can do this in my sleep now. The Constitution cannot be abrogated or suspended by any person, and may only be amended in accordance with the provisions set out in this Constitution. It is also that section sets out that it is the supreme law of the land. The next most important point is, of course, section 5, which is the notion of the common equal citizenry, and everybody is called a Fijian. As I highlighted at the CPA, even till today, I mean, I heard one of the speakers this morning, they can't say Fijian economy because everybody's so hesitant. They say the Fiji economy. But they will be quite happy to say the Australian economy. They won't ever say the Australia economy. They'll say the Australian economy. In Fiji, everybody says the Fiji economy. Even the journalists have a problem with that. We have to get over some of these complexes we may have. All citizens of Fiji shall be known as Fijians. It is unfortunate, but perhaps now important now, that in Fiji we actually have to put that in the Constitution. The Australians don't have that in their Constitution, but everybody is called an Australian. If you carry an Australian passport, I'm using the Australia because I can see Glenn sitting here. He said to me, I was speaking on the Australians, but hopefully I can see a Kiwi or somebody else in the audience. I see the British High Commissioner, maybe I'll use Britain as an example, one of the future examples. But we put that in place. The next section very quickly is, of course, the Bill of Rights. There is a very elaborate set of rights that have been put out. It includes, for the first time in Fiji's history, access to socio-economic rights. All the commissions that have gone throughout Fiji, whether it's the Guy Commission even previously, and through the Prime Minister's travels and all the Ministers' travels, and even through all the other permanent secretaries, one of the most common issues that people talk to the ministers about and the various officials is the day-to-day issues. They talk about access to water, electricity, jobs, economic participation, access to transportation. All of these provisions, all of these issues is what is key to them. And that's what they talk about. And therefore it has been included. And indeed, you'll see that the rationale or the philosophy behind that is that any government, irrespective of whichever political party they come from or is voted from, must always focus also not just on the civil and political rights, but also on the socio-economic rights. In the same way, you will see for the first time a provision for legal aid commission access. We can all talk about the rule of law, and everybody is equal before the law, but if you're a poor person, and if it says you have a right to a lawyer, it doesn't make sense if you can't afford a lawyer. But in practice, it does not make any sense. So you must have access to legal aid. And therefore, legal aid has been recognized, the services of legal aid has been recognized within the Constitution. Section 28 of the Constitution, before that is Section 26, which is the unfair discrimination provision. That talks about all the grounds under which a person cannot be unfairly discriminated against. And we've actually enlarged that. Previously it was somewhat limited. We've now included pregnancy, it's marriage, culture is also included. So you cannot be unfairly discriminated against on the basis of your culture, whether you're pregnant or not, your conscience, your religion, all those sorts of sex, gender, sexual orientation, etc. All of those grounds have been included in the unfair discrimination provision, enlarged. There are, however, exceptions to those. And one of the key ones that has been put in, if you look at subsection 9, it says that a law may, in fact, prevail over those unfair discrimination provisions in terms of, for example, setting up a retirement age for civil servants. Number 2 is that the law of marriage will always prevail. People in Fiji feel very strongly about same-sex marriage, as in they do not approve of it. And that is actually captured there. So you cannot discriminate against anybody on the basis of their sexual orientation. And I think everybody in this room will agree that we should not discriminate against anybody because of the sexual orientation, but that does not translate into same-sex marriage. And that's what's captured there. What is also captured in subsection 9, or G, is the prevalence of the customary practices of the Litauke, Bandaban, and Rotuman people in respect of enforcing issues regarding the communal ownership of their land, and also the bestowing of chiefly title or rank. Now what does that mean in practice? What it means in practice, for example, there are certain places in Fiji where the chiefly title cannot be held by women. That is a customary practice of that particular area. And so therefore that practice is allowed. There are certain other practices that may be put in force. For example, there may be a certain particular village that may put a, you know, exclusivity in terms of saying, well, let's not have any fishing for the next 2 months because of, you know, we want the resources to come up, or the chief has passed away, and the next villager simply cannot come along and say, it's my right and therefore I can come and fish. Because it allows for the communal enforcement of those particular provisions in terms of also access to marine resources. So that is also captured, and that is also a group right that is enforced. And you would have heard, some of you would have heard the past couple of days somebody making some statements to Reading Reserve saying it's not recognized. In fact, it is recognized. Section 27 it's always been there, the compulsory acquisition by the state for land for public purposes. Obviously, it applies to Itaukea land, freehold land, those two common land types of land. Section 28 emphatically sets out that the ownership of Itaukea land shall remain with the customary owners of that land, and Itaukea land shall not be permanently alienated, whether by sale, grant, transfer, or exchange, except to the state in accordance with the Section 27. That has never been included in any constitution in Fiji. Never. Emphatically stated in a provision in the Constitution. Subsection 2 goes even further. What it says is that if the state does acquire Itaukea land for public purposes, so for example, government may come along and say we want to build a road here, they pay the landowners fair compensation and they use that land to build a road. If in 20 years' time, 10 years' time, the government no longer requires that land because they've decided it's not a very good portion of the land, it's always, you know, gets flooded, we need to use another part of the land, they have to return that land to the customary owners, whoever they acquired it from. Previously what used to happen was that when the state acquired Itaukea land, or Rotuman land, or Bannerman land, but generally it was Itaukea land, it would then sit in the pool of state land. And those of you who may have actually exercised this particular right, you can actually convert state land to freehold land. So that's how Itaukea land got permanently alienated. Subsection 1 does not allow that. And in fact, the Prime Minister put in place subsection 2 as part of normal law, but in February of this year, we've now included that in the Constitution. And that is to stop the permanent alienation of land. Today, for those of you who may not know, about 91% of all the land in Fiji is Itaukea land. About 4 or 5% is state land, and the balance is freehold land. So there's that protection. Subsection 3 and 4, 5 and 6 gives similar protections to the Bannerman and Rotuman lands. Section 29 protects all the interests of all other lands. So if you own of a freehold land, what it says, it protects your rights. That continues as freehold land. It also says that if you want to buy and sell freehold land, that's obviously allowed. Of course, freehold land can be converted to any other land as long as you consent to sell it. That's your choice, whoever is the owner of freehold land. But subsection 2, very importantly, as I highlighted, nearly 95% of all the land in Fiji is leased land, can only be leased. There's protection for existing tenants and tenants who come in the future. That no government can in any way undermine the legal or tenancy agreement that you have in place with your landlord. So people talk about NALTA versus ALTA, etc. These are the fundamental protections that have now been put in place. So no government can come along and say, okay, you've got an agreement with the TLTB, we're now going to, increase the rent by 500%, or we're going to cut short the tenancy. Your entire tenancy is governed by the tenancy agreement that you have with your landlord. There cannot be any intervening law that comes in and in any way diminishes your rights as a tenant. So that's the protection that's given. Section 30 is obviously, for the first time, it goes away from the common law position of the ownership of minerals. Anything below 6 feet under common law, generally, it belongs to the state. Now, what this section does, it says that whoever is the landowner, wherever the mineral is found, mineral is defined to be, in the definition, to include things like gas and oil, etc. Wherever the mineral is found, the landowner is entitled to an equal share of any royalties that the state may get. That is very groundbreaking position in respect of the sharing of royalties. I mean, there are many wonderful stories, tragically wonderful stories about how, for example, in Batukola, the land that you see is the gold mine, in fact, used to be Itauke land. If you look at the land records in the earlier part of the 20th century, and around about in 1930, they made a conversion. Suddenly, that state land was given out as lease for 999 years. The landowners still today lament about that, but that obviously happened. We cannot turn back the clock on it. The fact is that there is a deep sense that there has been huge marginalization in terms of the ability to share the resources that comes from underneath the ground, in which landowners have proprietary rights. Of course, they can apply to freehold land. If you want freehold land, if they find oil, you get 50% of share of the royalties. The right to education, etc. is there, but what is, I think, very important in subsection 3, which is conversational and contemporary Itauke and Fiji Hindi languages shall be taught as compulsory subjects in all primary schools. As I said to previous gathering, that whilst, apart from political reasons and the fact that if you're able to speak each other's language, you're able to exchange jokes and share stories, etc., it makes communication a lot better, it removes misunderstanding, which does occur quite a bit. But also at the same time, from a purely business perspective, it presents to you a cadre of people who can speak 3 languages. If you are going to engage a salesperson, you don't have to worry about whether they can speak this language or that language. You'll have a person who will be presented to you and they can appeal to all your customers. And that is very important. You go to numerous countries like Switzerland, etc., people speak 3, 4 languages right from an early age. We should have the ability to do that also. It will also mean that in a few years' time, when a person goes over to a civil servant, if they do not speak, for example, English very well and want to speak one of the vernacular languages, they don't actually have to wait for a civil servant who speaks that language. That civil servant should be able to speak or converse with them in all the languages. So it improves efficiencies also. So I think that is significant from that perspective. The next significant change, of course, is that we have put in place the new parliament. There is now 50 seats in parliament with proportional representation. There is going to be one single constituency as opposed to previously where you had, in the draft, we had the 4 divisions, western, northern, central and eastern. Now the entire country will be treated as one constituency. You have one vote, everybody goes and votes once, and your vote is then counted and put together under the list of the party you vote, and you get proportionally, that party gets the proportional number of seats in parliament. We can give you more details on that, but the seat numbers have been increased to 50 from the original 45, very much in line with the NCBBF recommendation. And we also have, for example, removed the mechanics where previously if somebody, a political party, won majority of the seats, it then had to go and show to the president that, I have majority of the people in the parliament supporting me, therefore please appoint me as prime minister. Now it's an automatic process. If you are the leader of a political party that has won more than 25 seats in parliament, you automatically get sworn in as the prime minister. So those kind of bureaucratic processes have been removed. We also have built in the Human Rights Commission. Before I go into that, the Human Rights Commission has been renamed the Human Rights and Anti-Discrimination Commission. Its scope has been enlarged. It is now given a charge over government funds, as all the other independent institutions are. And we then, as far as Parliament is concerned, we now also say that there must be a committee system within Parliament. It's stated specifically in the Constitution. So we have a lot more deliberation and debate about various topics and issues. I'd like to very much focus on some of the key independent institutions. If you look at the judiciary, we've always talked about how the judiciary in Fiji has always been independent. But I think if you look in the past, the fact is that in some practical senses, it's not actually independent. Because firstly, if the CJ, like the example I gave earlier on in other forums, if the CJ tomorrow, the Chief Justice wants to transfer somebody from the Bar Court to the Tahua Court, he actually has to get the permission of PSC. Sometimes they may not agree with that. Sometimes, for example, the PSC may send somebody to the judiciary, to be a counselor, etc., with absolutely no experience in family law, because they're seem to be part of the civil service. The judiciary, to be truly independent, needs to also control not just its finances, but also its staffing, in the same way as it does the appointment to the bench. So, for the first time, you'll see that judiciary has control, subsection 6, control of its own budget and finances as approved by Parliament, of course. You have a Judicial Services Commission, a 5-member Judicial Services Commission. Previously used to be 3. Now, for the first time, there's a requirement that one of the commissioners on the Judicial Services Commission must be a layperson. Could be one of you, could be somebody from the civil society, I suppose you're part of civil society, could be anybody, but a non-lawyer. Preferably not an accountant, but a non-lawyer. So you'll see it consists of the CJ, President of the Court of Appeal, Permanent Secretary for Justice, a legal practitioner with not less than 15 years of post-admission experience, and a person not being a legal practitioner. Then we have all the quasi-judicial officers. So FICA, you have the Solicitor General's Office, the DPP, the Mercy Commission. All of them are listed under this particular section, and all those members there are appointed by the Judicial Services Commission in consultation with the line minister. We are also, for the first time, going to put in place an Accountability and Transparency Commission. The Accountability and Transparency Commission actually holds public office holders accountable. The President, Prime Minister, ministers, and senior civil servants right up to director level. You can lodge complaints about these people to them. They have a specific requirement by law to in fact protect whistleblowers. So for the first time, protection for constitutional protection for whistleblowers. That is very, very important. And they are of course independent again. All these officers are appointed, the commissioners are appointed by the Judicial Services Commission. They also will manage the information regarding public office holders, because as you will see later, under the code of conduct that we hope to implement by the end of the year, if you're a public senior civil servant, or you are the Prime Minister or Minister or President, you have to declare all your assets and liabilities. You will then, as individual citizens of this country, be able to know exactly how much they earn, what is their revenue base, what are the assets they have, what assets do their spouses and children have. Now that is very important, in particular when we've had this era of unchecked public office decisions being made, and obviously people benefiting from it. And if I declare that I've got $50,000 in my bank account, and you see that, and then the following year it's gone up to $1 million, and that's the only source of income I have, there's obviously something very wrong. I have not inherited the wealth from my grandfather. The point is that you need to be able to know where you got the money from, and you need to be held accountable. So people who hold public office, the philosophy is that their private lives also need to be made public. The freedom of, the next section then is in respect of the Judicial Officers Commission, the President's office. The President holds a term for 3 years, can be reappointed for another term of 3 years, but there's a cap of 2 terms. We had very strong submissions from people saying that the President should be somebody who's never had an offense or been found guilty of an offense. Of course, a parking ticket can be an offense too, or speeding ticket. So maybe somebody who's at the age of 20 driving along and gets booked for speeding, in 50 years' time they may make a good president. They won't be eligible for it because they've had 50 years ago they had a speeding ticket. So we've rationalized that, and we've said that the president should be somebody who should not be found guilty of any offense, and there should be a stand-down period of 6 years. So if you've been, if you're a president and you, for example, had a speeding ticket, so wait for 6 years before you can be nominated. And you obviously get nominated by the Prime Minister and Leader of Opposition, and the House of Reps actually votes for the President. Similarly, and this would be relevant to some of you, who qualifies to stand for Parliament. The normal qualifications are there, for example, you cannot be undischarged, bankrupt, etc. But as you know, that now we allow for dual citizenship, and you can vote if you're a citizen of Fiji and a citizen of any other country or other countries, as long as you have a valid passport and a registered voter. but you cannot stand for elections. You can only stand for elections if only you're a Fijian citizen, if you're a Fijian citizen only. You cannot be a citizen of any other country. And that's a requirement. I think Australia still practices that, and a number of other countries have that in place. You also, for example, cannot be, any time during the 8 years immediately before being nominated, being convicted of any offence under any law for which the maximum penalty is a term of imprisonment of 12 months or more. So, if you're being booked for not paying a parking ticket, you still qualify because it does not carry of imprisonment sentence of more than 12 months. So the minor offences really, you can still stand for Parliament. We've set the minimum threshold, but of course at the end of the day it's up to you, the voters. You want to elect somebody who has been convicted of rape 10 years ago, good luck to the voters. That's their choice. But we've set a minimum threshold of 8 years. For any offence that carries a maximum penalty of more than 12 months. The other important section is chapter the PSC one. The public service, you'll see that for the first time, again it goes to the topic of discussion this morning. For the first time we've included those values and principles in the Constitution. So the civil service must include high standards of professionalism, including ethics, integrity, prompt and faithful implementation of government policies, being free of corruption, efficient, effective and economic use of public resources. Just because you get a government vehicle doesn't mean you take it home. Prompt responses to requests and questions from the public, and delivery of service to the public in a manner that is respectful, effective, impartial, fair and equitable. Very, very strong submissions from members of the public. Many people were quite very, very emotional when they spoke about the civil service. And some of them were very upset, saying we do not get, for example, responses to our phone calls, or we do not get people responding to our letters, and it's like we don't mean anything, but we actually pay for the salaries. So that has been included there. So it's a constitutional provision now. And of course, they need to be held accountable. You need to have the civil service promotions and recruitment needs to be made on merit. There needs to be objectivity, impartiality, and fair competition. There's a lot of strong submissions on that, given the previous practices. The other significant change is that the permanent secretaries will have a lot more control over their specific ministries, where they're given control of their budget and recruitment, etc. So they are able to then hire the best people at the right rates. We find, for example, some of the positions that were created in some of the civil service positions that were created previously are no longer relevant. Example that I give is that we had a person who may be appointed, or there's a position to look after all the vehicles in the ministry. The ministry may have only one vehicle or two vehicles. There's no need. Your PA can look after the vehicles. Now most of government vehicles are leased in any case. So the company comes and regularly takes it away for servicing, etc. So you don't need that position. But that money perhaps can be used to offer a better salary to somebody holding a professional position. We do compete with the private sector. The private sector does poach people. Regional organizations does poach people from the civil service. The Director of Environment is leaving now because he's got a job by Spread in Samoa. So we are losing that intellectual capital also, and we need to retain that intellectual capital within the service. And one of the ways that we can do that is by having a very good not just working environment, but also be able to offer attractive salaries. And sometimes a ministry, instead of being run by 60 people, can be run by 30 people who have the right skill sets. Alternatively, there may be certain ministries that only have 20 people, but they have a lot more face-to-face encounter with the public. So they need to probably increase their numbers also. There's a bit of horses for courses depending on which ministry it is. The other main section is, of course, before I forget, elections now will be held every 4 years. It can be in fact held within 3.5 years. A government that is elected must run for at least a period of 3.5 years. Between 3.5 years and 4 years, they can call elections at any time between them. So elections now will be held sooner rather than later. And and we have a strong emphasis on developing the elections office to be truly independent and a strong institution. Previously, for example, whenever elections, after elections, some ministry would go and take away all the computers, some would take away all the two-way radios, etc. We cannot have that. It's a raping and pillaging of the elections office. We want to ensure that the elections office is maintained as it is. We build the capacity and we maintain the capacity. It needs to be specific career path with the elections office. The elections office should not simply be to conduct the national elections. It should be there to conduct if future, for example, if you have elections for municipal councils, or indeed other private organizations, many sporting bodies. Fiji Football Association, as you know, is held not to be very democratic. So they may actually want to call the elections office to conduct the elections, provincial council meetings, any other organizations that they might want elections conducted. The elections office can provide that, because the idea is to engender and inculcate an idea of democracy, not just in terms of verbiage, but also in the practical sense. We have the next main section, of course, the immunity provision. If you turn to, I think it's chapter 10. There is an immunity that's been given to, firstly, the immunity that was given for the events of 1987. As you know, that there were 2 coups in 1987, and there is specific immunity given to those who were involved in that in the 1990 Constitution, and that immunity provision continued in the 1997 Constitution. That continues also under this Constitution, and also immunity is given to the events pertaining to 5 December 06 to the President, Prime Minister, Cabinet Ministers, Republic of Fiji Military Forces, Fiji Police Force, Fiji Corrections, Judiciary, public service in any public office, both in their personal and in their official capacity. And that immunity obviously will continue. That immunity cannot ever be amended. That, of course, for obvious reasons, is to give stability, as the drafters of the 1997 Constitution did not remove the immunity that was given to those who participated in the events of 1987 to give it that stability. However, there is a specific provision that says the immunity does not extend to those offences that are listed there, 133 to 146, etc. They relate to things like corruption, abuse of office, murder, rape. Nobody has immunity from that, and those provisions are there. Immunity, as I said, is entrenched. The following provision in respect of the amendment of the Constitution that essentially says that the immunity provisions cannot be in any way diluted, nor can it be taken away, nor can, of course, the amendment section be diluted. The amendment of the Constitution will now take place if 3/4 of Parliament agrees to amend any section of the Constitution. That's the first layer. You have to have 3/4 of Parliament support an amendment. And after the third reading, if that's approved, then it must go to the members of the public. 3/4 of them have to agree. And it's not 3/4 of the people who vote, but 3/4 of the registered voters. It's 3/4 of the registered voters must support an amendment before it can actually take effect. The reason why I put 3/4 of the registered voters is because if you look at the American system, I think for the last elections, for the presidential elections, I think it's about 53% voter turnout. Or sometimes it's 51%. You don't want a situation where in Fiji 100,000 people just simply turn up for an amendment, and if 75,000 agree to it, they can actually amend the Constitution. You need to have 3/4 of the registered voters. The next main important section is the transitional provisions, which specifically talks about what will happen from the time that the President assents to the Constitution and it coming into effect to the first sitting of Parliament. Essentially what the section talks about, the key points that I'll highlight, is that the President must give at least 60 days notice before the holding of elections. So people know at least 2 months in advance when the elections will be held. And then subsequent to that, the writs will be issued. Nominations must be at least 30 days before the elections are held. So at least you know who the candidates will be. The other significant point, of course, is that in respect of all the decrees that have been put in place by the Bainimarama government, the decrees will continue. The validity of the decrees cannot be challenged. The decrees continue right up to the first sitting of Parliament, and of course it can continue thereafter. However, should the elected government want to change any of the decrees, repeal it, amend it, expand on it, they can do that. That's their choice, because that's the elected parliament. However, that parliament cannot go back in time. In other words, for example, if the new parliament comes in and says, let's increase corporate tax now to 40%. Some parties may want to do that, and you've got to be careful who you vote for. Some of them may want to increase it to 40%. So, they can do that. That's their choice. But they cannot go back and say, well, you must pay us 40% in 2013. Because we want to recoup that. They cannot go back in time. There's no retrospective application of any amendments to any of the decrees that will be made. Or if they want to get rid of the domestic violence decree, they cannot say, oh, they can get rid of it, but they cannot go back and say, well, the person who was sent to prison for beating up his wife under the domestic violence decree, now let's get him out or let's pay him compensation. Because that was the law at that point in time. That again is to give stability to the provisions that had been put in place. A number of the provisions, as you know, for example, was put in place because to address many of the lacunas in the law. I'll give you an example. In the case of Natandola, you had a person who was a shareholder in Natandola Bay Resort Limited, who was an undischarged bankrupt, was wanted by certain authorities in Europe, but was a shareholder in NDRL. If that decree had not been put in place, he would still today be a shareholder of that. He had made false declarations in his application for the foreign investment certificate with Investment Fiji. There was absolutely no provision in any of the existing laws at that point in time as to how to provide a redress. I was asked the other day, why have you brought about certain changes in respect of the investment laws? If people come to Fiji, we have now reduced the investment thresholds, and it's a lot easier for people to come in. But we want them to make honest declarations. We want them to stick to the very certification that is given to them. If you're given certification to operate business X, you don't go into business A and expect not there to be any repercussions. So that's the basis in which some of these laws have been put in place, and indeed some of the amendments have already been made regarding them. So ladies and gentlemen, they are the key amendments that have been made via the new constitution. And what I would like to say, and as you know that we'll be talking about the various sections of the industry, and as has been highlighted through the Talanoa session about a week ago, there are of course a number of areas in which the Bainimarama government is trying to improve and indeed recognizes some of the lapses in the manner in which perhaps some of the delivery systems have not been working, some of the services have not been delivered in the manner in which we wanted. There are a number of challenges. We indeed are fixing up decades of problems. A very simple example is that we should have had, for example, the company's office and the title's office all digitalized and all computerized, but it's not. And we are dealing with it now. We've just outsourced government's IT services, and we hope to have that on stream by the end of the year in many of the areas, and indeed by the end of the first quarter of next year. There are those types of issues. There are also issues in respect of, for example, many of our laws. We still have laws going back to 1894 in respect to trademarks. We have development laws or application laws that have not taken account of the change in technology or change in the engineering methodologies and systems. So how far you build away from a river bank or how far you build away from the side of a mountain, all of that is out of sync. And so some bureaucrats know that. Many of you, of course, know that. The engineers and architects know that. So there is this hole in terms of what is out there and what can be implemented, and the law is actually not sinking in. So we have, in fact, over the past week ago, Cabinet has also made a decision, and you'll see some publicity around this. In the next couple of weeks, we'll be going around Fiji to, for example, get feedback from members of the public, from business communities, and also from the small to medium enterprises, where we want to find out as to how we can, for example, fast track some of these areas and how we need to marry the laws that are out of sync with current practices. I'll give you an example. We have, for example, a gentleman I know as a live example who runs a small shoe repair shop in Lautoka Market. His gross income is about $9,000 a year. But the fees that he has to pay for business license fees, OHS, NFA, etc., is about $700 a year. So it's nearly 10% of his gross income. So we are looking ways as to how we can perhaps provide minimum thresholds in terms of the application fees, in terms of business license fees, and how we can perhaps expedite some of the application processes. We've seen recently in the past few days regarding some of the issues pertaining to EIAs. I also know there's a bit of a lapse in the law where if you are a developer and you've made an application to TCP and they come up with a ruling on it, you as a developer, the only way you can challenge that is if you go to court. But if you are somebody who's objecting to the development, your objection can be taken to the minister, whereas you as a developer don't have the right to go to the minister. But at the same time, we want to ensure that we do not give too many discretionary powers to the ministers, because that leads to corruption also. So that's where we need to be able to balance those requirements, and how perhaps we can, and we're thinking along the lines of having an independent panel of engineers, architects, etc., who can provide that input to be able to make decisions and indeed expedite those processes. I look forward to the discussion today, and please be aware, and as I've said earlier on, that we're here to listen. We want to work together with you to help improve the processes and the systems that are in place. There are many positive aspects also that has been, many positive things have happened, and I see Arvind shaking his head very reservedly, but it has happened, and we have received a lot of positive feedback. But of course, that does not mean that we become complacent about it. Indeed, that's what the IMF report said. The momentum that's there is actually very, very good, and we cannot become complacent about it. We need to take advantage of it. And we hope to do that, because once we have these sorts of political, constitutional issues resolved, we can then focus on the big picture and the actual, at the micro level too, as to how to improve the services, indeed, provide the economic growth rate and improve the livelihoods of all Fijians. Thank you very much. Vinaka.